The clerk can go ahead and call the case then, please.
The Court of Appeals for the 8th District of Texas is now in session.
Good morning. We're here today on one case, cause number 08-19004 civil, Bernardo Gonzalez versus Momentum Design and Construction from El Paso County. We are having an oral argument pursuant to Zoom, which is pursuant to a Texas Supreme Court emergency order. And for the litigants' benefit, I'll tell you that we have read your briefs. We haven't had an opportunity to discuss the case amongst ourselves. And we are happy to say that our computers are largely back online and working, and we've had an opportunity to extensively get into the record on this case. So with that said, Mr. Pownell, you may proceed whenever you are ready, sir.
Thank you, Your Honor. Good morning, everybody.
Good morning.
Jeff Pownell of Sharon Legate on behalf of the appellant, Bernardo Gonzalez. It may please the court. I'm going to take one moment to try to organize my papers, so hopefully I don't have to move them afterwards, so that to try to avoid any static or feedback. Okay, I think I'm okay. As the court knows, this is an appeal of order granting a Chapter 150 motion to dismiss for failure to provide a certificate of merit. There were several issues raised in appellant's brief, but unless the court has any questions, I'm going to focus this morning on two of the issues. The first issue is statutory interpretation, and the second issue is the waiver issue. Let me first just, I know the court is familiar with the record. I'm going to just summarize the facts briefly. Mr. Gonzalez worked for El Paso Electric, and he was injured on September 20th of 2014 when he fell through an unsupported fiberglass cover while working for El Paso Electric at a substation house on Montana. He filed suit. He filed a petition against the defendant, and then filed an amended petition against CSA contractors. Then just a few months, 2 or 3 months before limitations was going to end, CSA then did a couple of things that I'm sure the court is familiar with that's going to be important to the issues in this appeal. But the first thing they did is they responded to some interrogatory requests, and also requests for disclosures. And in those interrogatory requests, they identified Momentum. And let's see, Momentum's full name is Momentum Design and Construction, Inc. That's the appellee, but I'll just refer to it as Momentum. CSA identified Momentum as a potentially liable third party. This would be on July 21st, I believe, of 2016, in answering a discovery, responding to requests for disclosures, and in providing sworn interrogatories that was verified under oath. So 7 days later, very promptly, the plaintiff filed a second amended petition naming Momentum as a defendant. And so Momentum then appeared and answered on September 1st of 2016. And then just a few days after that, another, what we believe is an important thing happened, because on September 7th, 2016, just 6 days later, CSA, the co-defendant, filed a motion for leave to designate Momentum as a responsible third party. And so not only were the sworn interrogatories and responses to requests for disclosures filed back in July and that were part of the case, but even after Momentum filed their answer, just 6 days later, CSA filed their motion for leave to designate Momentum as a responsible third party. And here's what they said in their motion. They said it believed the design of the substation was designed by Momentum, and the design of the substation specifically did not include the addition of a lateral support beam in the location where plaintiff fell. CSA constructors further alleged that to the extent support beams were needed, Momentum, as the professional architect and engineering firm, should have designed the substation to provide for the lateral safety support beams. So that was in a co-defendant's, CSA's motion to designate Momentum as a responsible third party that was filed in the case 6 days after Momentum had appeared and answered. And I'm going to go dive straight, and the court probably knows from the briefing that an extended period of time ensued after that, about a year and a half, 17 months, or I think 559 days, depending on how you want to calculate it, before Momentum filed a motion to dismiss. During that period, and it's set forth, I think, in fair detail in the appellant's brief, but Momentum basically sent out discovery requests, sent out deposition notices, sent out document requests by subpoena duces tecum, agreed to a discovery control plan, did all these things for an extensive period of time, for a 17-month period, before filing its motion to dismiss. And let's see, filed their motion to dismiss on February 6th of 2018.
Counselor, can I interrupt you just for a minute?
Sure.
While you're talking about the discovery control order. The order, I guess, that was agreed to by the parties said that dispositive motions could be filed, or had to be filed, up until, I think, July of that year. And so Momentum files its dispositive motion in February, which would have been essentially 5 months before that deadline. Does that give you any pause that perhaps your client had kind of agreed that dispositive motions could be filed through the end of July?
I don't believe so, Your Honor, and I think there's a couple of responses to that. The first is the Lalonde decision that addresses the issue of waiver, which the focus is on waiver of what, and the issue of wavering what is in our circumstances here, whether the claim was non-frivolous, whether the claim was frivolous or non-frivolous. But I think the larger point, Your Honor, is that I guess there's no really further delineation or explanation of what dispositive motion means in that context. But I think everyone understood a dispositive motion to be a motion for summary judgment or some kind of decision on the merits. And even though a Chapter 150 motion to dismiss can be with prejudice, it's still not a decision on the merits. In the sense that it was, in the sense that any of the issues were fairly and fully litigated. So I guess just off the top of my head, Your Honor, the third thing I would argue is that I don't remember that being an argument in the appellee's brief. But even if it were, because that, if we logically follow that argument, Your Honor, because if there's no waiver, we don't have to get to that. So that argument, I think, necessarily has to be, one, there was a waiver of Chapter 150 by Momentum, but then based on their conduct, which is what we've argued, of course, but then I guess the logical follow to that would be that Mr. Gonzalez then himself agreed to resurrect their right to a waiver by virtue of the discovery control plan. If the court follows my logic here, because they're really two independent events, at least I believe they are for the reasons I'll discuss here in a second. But so the short answer to your question, Your Honor, is I don't believe that agreeing to a discovery control plan would revive Momentum's ability to seek a Chapter 150 motion to dismiss. You know, there's probably one other thing. Again, I'm just thinking off the top of my head. My memory is that in Lalonde, there was also the party also agreed to a discovery control plan. And it seems like my memory is that that was part of the record. Now, Lalonde, the motion to dismiss was only filed a month or so before trial. But I'll be happy to go back and look at the Lalonde decision and see if there's a discovery control plan there. Because my guess is that if there was, there would have been a deadline for dispositive motions in Lalonde as well. And so, so anyway, I don't know if that answers your question, Your Honor, but I think the shorter answer is, obviously, if there had been language that said the plaintiff agrees to allow Momentum to file a Chapter 150 motion to dismiss, I mean, that would make my argument a lot thinner. But I just don't believe anybody really understands. That's a standard, as the court knows, that's a standard phraseology that's in almost every discovery control plan. And the parties all understand that to really be focusing on a motion for summary judgment. Okay. So before I dive into the arguments, I did want to add one more piece of the statute of Chapter 150 that I do think is indirectly helps the plaintiff on the statutory interpretation issue, but I think it directly helps the plaintiff on the waiver issue, and that is 150.002D, because Chapter 150.002D states the defendant shall not be required to file an answer to the complaint and affidavit until 30 days after the filing of such affidavit. So why does that matter? I think it matters because one of the arguments that Momentum has made in its brief several different times to try to explain the year-and-a-half delay, the 17-month delay before filing the motion to dismiss was that they wanted to find out more about the case, to paraphrase. You'll find that kind of throughout the Momentum's brief. But what we know from the statute is they didn't have to find out anything about the case in order to file a Chapter 150 motion to dismiss. The only thing they had to know was when they were served with the Second Amendment petition. The only thing they had to know was whether, if Chapter 150 applies, the only thing they had to know was whether a Chapter 150 affidavit was attached to the petition. Once they knew that that was not attached, they didn't even have to file an answer. The statute allowed them to file a motion to dismiss. So the argument that they engaged in this extensive discovery for 17 months in order to find out more about the case really has nothing to do with the issue of whether they could file a Chapter 150 motion to dismiss. Because they always had the ability to do that under the statute the moment they could determine that there was no affidavit attached to the Second Amendment petition. Okay. One other quick procedural matter that I think would like to address sooner rather than later, just so I don't run out of time. And I'm just trying to, this is my first time to do this, Your Honor.
You have 11 and a half minutes.
Okay, thank you, Your Honor. So I'm about halfway there. The procedural matter I want to address is in the SIR reply brief. Momentum argued that the court, that our matter of law argument with respect to the waiver was not fairly subsumed within as part of our appellate brief. And I just want to address that procedural matter very briefly, because in Momentum's own appellee brief on page 17 of the brief, the section, the title is "The Undisputed Facts Regarding Momentum's Conduct in Relation to the Issue of Waiver Were Considered and Implicitly Denied by the Trial Court as a Question of Law, and the court did not abuse its discretion in implicitly denying appellant's argument of waiver." So in other words, when we wrote appellant's brief, argued that the trial court didn't rule on the waiver issue and it needs to be sent back. Of course, we didn't have the benefit of the Lalonde decision. And so after the Lalonde decision, it became fairly apparent to me that what Lalonde says is if the facts are undisputed, then it's a question of law, and the appellate court decides it de novo. So in the cert reply brief, Momentum argued that, well, that issue is not fairly subsumed under our appellate point. But I would just point out, I think you have a hard time arguing that it's not fairly subsumed when you address the exact issue in your appellee's brief, because the issue that's fairly subsumed in the reply brief was that, okay, there aren't any undisputed facts, and based on Lalonde, we don't need to send it back to the trial court because no one is disputing when the second amendment petition was filed, when Momentum answered, all the discovery that took place. These are all undisputed facts, Your Honor. So even though I do believe the trial court, the record shows that the trial court did not rule on the waiver issue, I also believe after the Lalonde decision that because there are no disputed facts with respect to the waiver issue, at least that I'm aware of, that it becomes a matter of law issue that this court can review de novo, and that issue is fairly subsumed in our brief. And as I said, it's addressed by Momentum, not in its cert reply brief, in its appellee's brief, in its opening appellee's brief. That issue was already addressed by
So Mr. Pownell, just so I make sure I understand, you're saying to the extent there may have been a shift in your position regarding whether it was you could decide it as a matter of law or if there were factual disputes. If there is a shift, it's because it was impacted by Lalonde?
I think that's right. I think that's fair. I mean, this is, let me try to summarize it a slightly different way. Our argument is that Judge Baril should have addressed the waiver issue and did not address the waiver issue. And she specifically said in the record that she didn't feel like she needed to address the waiver issue. And so that was our argument. And by the way, just to address another procedural default argument, Trap 33 specifically says, Trap 33C specifically says, formal exception and separate order not required. Neither a formal exception to a trial court ruling or order nor a signed separate order is required to preserve a complaint on appeal. Because one of the things Momentum argued was, well, we didn't get an order with Judge Baril saying, I'm not going to rule on this. But Trap 33C says you don't have to get an order. Now, what you do have to do is you have to make the timely objection, or you have to make the complaint to the trial court by a timely request, objection, or motion that states the ground for the ruling that the complaining party sought from the trial court with sufficient specificity to make the trial court aware of the complaint, or the specific grounds were apparent from the context. And the trial court has to rule on it or refuse to rule on the request, objection, or motion, and the complaining party objected to the refusal. So that's the last key phrase, the complaining party objected to the refusal. So I guess what Momentum is arguing is that we didn't stand up and formally say, we object to the court's refusal to rule. But as our brief points out, Mr. Isaac, there was a dialogue that went on for 2 or 3 minutes where Mr. Isaac explained to the court that she needed to rule, and she said, no, I don't need to rule. So then you have to look at 33C that says you don't need a formal order. You don't need to formally say, I'm making a special exception to the court's refusal. You just have to do it in a way where the court understands what you're ruling. Okay, so now I'm really going far afield here.
Okay,
Because-
so I'm looking at the clock, and so I want to just make sure I can ask you on the waiver argument.
Okay,
And I'm assuming you agree that we apply a totality of the circumstances test.
that's right.
So we have to weigh a variety of factors. Which of the factors that we need to weigh do you find most compelling to your argument?
I think the most compelling argument, or the most compelling factor in our case, is the sworn interrogatories from a co-defendant, identifying Momentum as a potentially liable party in their request for disclosures, and most of all, the motion for leave to designate Momentum as a responsible third party 6 days after Momentum answered. Why is that significant? That's significant, Your Honor, because this goes back to Lalonde, where Lalonde went really out of its way to great lengths to explain how waiver in the Chapter 150 context is much different than waiver in the arbitration or the forum selection clause context. And I would suggest, Your Honor, that the focus is on what's the purpose of 150? It's to dismiss frivolous claims, right? So when Momentum says we needed to take a 1.5 year discovery to find out more about the case, that's not really related to whether your claim is that makes sense in order to file a motion for summary judgment, but it doesn't make sense to file a Chapter 150 motion to dismiss. And it particularly doesn't make sense when you don't even have to file an answer. But here we have a motion to designate a responsible third party made by CSR, a co-defendant, 6 days after they answer, that specifically states, and I know I said that at the beginning of the oral argument, but they're basically they said, the liability belongs to Momentum. Momentum's the one that designed this. If the fiberglass covering wasn't supported, Momentum's the one that designed that. So Momentum had notice, and like I said, and it's supported by evidence because they're sworn interrogatory responses that are part of the case by CSR. So we've got evidence and we've got a motion to designate a responsible third party 6 days after Momentum answers that says this claim against Momentum is not frivolous. It's a non-frivolous claim, because that's all we're trying to find out.
Okay, so let me ask you then, real pointedly then, what to you is the import of that designation by CSA with relationship to the statutory requirement? Are you making an argument to say that that particular pleading could substitute for a certificate of merit, or is your argument different than that?
It's different than that. The argument is waiver. So waiver means, intentional relinquishment of a known right or conduct inconsistent with that right. And the Supreme Court in Lalonde said, and by the way, we're in the middle of a rainstorm. I don't know if you guys can hear that, but it's loud here. Okay. So Lalonde said, when the facts are undisputed, that's a matter of law issue. So no, I'm not trying to suggest that the motion for leave to designate them as a responsible third party is a substitute. What I am suggesting is, one, Momentum already knew from 150 that they didn't even have to file an answer. So that in itself is some evidence of waiver. And the Supreme Court made clear that when it comes to Chapter 150, anything you do in litigation is inconsistent with waiver. That's different than arbitration or forum selection clause, because in those instances, it's just the decision maker. So, going through with discovery is not inconsistent in the arbitration context, but it's completely inconsistent in the Chapter 150 context, because that's the only purpose of 150 is to determine whether a claim is frivolous or not. So now we have a motion to designate leave as a responsible third party. Momentum sees that, and now there's even more evidence that they need to file a motion to dismiss if they believe it's frivolous, but they don't do anything. So they allow they don't do anything after a motion for leave to designate a responsible third party is filed. Then they go through a year and a half of discovery with deposition notices, not just one or two, as the record shows, but over and over and over. Deposition notices, subpoena duces tecum, written discovery, forth and back. And 559 days later, finally files their motion to dismiss. Now, Lalonde was 1 month before trial. We're 7 months before trial. But is that really a meaningful distinction for purposes of Chapter 150? I mean, it probably would be for arbitration, because what's involved in arbitration is the decision maker. So it probably would make a difference for arbitration, but not when you're trying to just at the outset of the lawsuit try to determine whether the claim is frivolous or not. So that's why I believe that those three together, the sworn interrogatory responses from CSR that were part of the case that Momentum had notice of, the response to requests for disclosures that identified Momentum as a potentially responsible third party, and then probably most importantly, the motion for leave to designate responsible third party.
Thank you, counsel. I'm going to put you on mute and then unmute Ms. Lopez. So whenever you're ready. Oh, wait, stop. Okay.
Good morning, Your Honors.
Let's try that again.
Sure. Good morning, Your Honors. Noemi Lopez on behalf of the appellee, Momentum Design. I'm going to go ahead and start by addressing the issue of whether the statute applied to Mr. Gonzalez at the time that he filed his second amended complaint. Mr. Pownell has suggested that because CSA Constructors had responded to discovery identifying Momentum Design as a potential party and a potential responsible third party, that somehow that gave Momentum Design notice that they needed to move to dismiss, or somehow that absolved Mr. Gonzalez from having to file a certificate of merit when he filed the second amended pleading. Mr. Gonzalez is the plaintiff in this case who was seeking damages against Momentum Design. He basically, below in the trial court and in his appellant's brief, he argued, he was more like a third party defendant or a cross claimant. The Jaster case, which is cited in the briefs, found that as to third party defendants and cross claimants, no merit of certificate would be required. But here, Mr. Gonzalez was the plaintiff who initiated the action, first pleading that initiated an action against a registered professional, which arose from the provision of those professional services, was the second amended complaint. It was not the petition that was filed against CSA Constructors, who was the general contractor in the case. The merit certificate would not have been required at that time. It was required when he filed the second amended complaint against Momentum Design. The case law is clear that a plaintiff is required to file a certificate with the first filed complaint asserting a negligence claim against a professional. I refer to the court to the cases in my brief, Sharp Engineering versus Lewis, Hakal Enterprises, Nangia versus Taylor, TICN, Central Dallas. All of those cases stand for the proposition that the statute requires the plaintiff to file the certificate of merit with the first filed petition in action that raises the claim subject to its provisions. I will also refer the court to a newer case, Barrett versus Berry, out of the Corpus Christi Court of Appeals. It's an unreported opinion from October 2019. In that case, the court held, and because the number is 1318-00498 CV 2019, Westlaw 4866041. In that case, the Corpus Christi Court of Appeals held that the trial court did not abuse its discretion in granting the defendant's motion to dismiss where the plaintiff filed his first amended petition, the first petition that named that defendant brought him in as a party to the suit without contemporaneously filing the meritorious certificate. Additionally, I'd cite the court to TDI Industries versus City Court, and the citation is 378 Southwest 3rd 1, and that's a Fort Worth Court of Appeals. In that case, the Fort Worth Court of Appeals concluded that discovery has no bearing on whether a certificate of merit is required. The statute itself contemplates that the determination of whether a certificate of merit is required is determined at the time the claim is filed before discovery. The court concluded that the proper approach when determining whether a certificate of merit was required is by looking solely at the pleadings to determine the nature of the claim. So here, it's undisputed second amended petition is the first filed pleading that asserts claims that arise under the statute against a registered professional. Plaintiff did not comply with that statute, so the trial court properly dismissed his claims. If the statute is not applied this way, it would allow plaintiffs to just amend their pleadings after they file suit against a non-professional to add registered professionals and bring their claims that way, and they would circumvent the purpose of the statute. Additionally, I'd point out that the statute or the chapter has been revised for a 5th time by the legislature. Under Senate Bill 1928, the legislature changed the language in the statute from the word plaintiff to claimant to clarify that any party seeking to sue the licensed professionals for malpractice is required to file a merit certificate. New definitions were also added to the statute, and the complaint is defined as any petition or other pleading for which for the first time raises a claim against the licensed or registered professional for damages arising out of the provision of professional services by the licensed or registered professional. While the amendments don't apply to the version that the court is construing today, the legislative history of the amendments reflect that the legislature has disagreed with how courts have interpreted the statute, and they reacted by amending the statute to clarify that under the statute, all claimants or parties, including a plaintiff or third-party plaintiff, are required to file a certificate of merit when the party is seeking recovery for damages, contributions, or indemnification. So addressing the responsible third-party designation is not that CSA filed. I'd point out that it's not a claim that CSA brought against Momentum. It's the responsible third party is a shifting a burden mechanism. It's not a claim for damages at the time. Under the new statute, CSA constructors would have been required, if they had actually filed a cross claim and sought some type of relief in form of contribution, they would have been required to file a certificate of merit. I'm going to go ahead and move on to the issue of waiver, Your Honors. In Lalonde, which I guess came to existence while this case was on appeal, the defendants did not seek dismissal until the eve of trial. The lawsuit had been on file for about approximately 40 months before motion to dismiss was filed. The engineers had engaged in discovery until all the discovery deadlines had passed. They designated experts. They did file motions. They filed an amended answer with affirmative defenses, but did not assert the right to dismissal. They participated in 2 mediations, and then they continued to participate in mediation or settlement negotiations after they moved to dismiss, and even continued the hearing on the motion to dismiss to continue those settlement negotiations. Why is
Counsel, if I can interrupt you just a little bit on the Lalonde case.
Yes.
There was 40 months between, I guess, the initiation of the suit and when the motion was filed. But then the court makes the point that there was a 20-month period where essentially nothing was happening because I guess they were negotiating and the architect or engineers had not even filed an answer. But then after that, there's an 18-month period when all of this discovery takes place. And so we're kind of dealing with a 17-month period. That's kind of what I'm struggling with is the time periods. Because the law stand for the proposition that an 18-month period of engaging in discovery is something that would count against the defendant or would be indicative of a waiver.
I don't believe so, Your Honor. In Lalonde, the court specifically notes that a lengthy time period by itself is not conclusive of a waiver or an intent to waive. The court also confirmed that in Crosstech, where the 8-month period that passed, the parties engaged in discovery, took depositions, and were trying to learn about the case. So I think we don't fall on, temporally and factually in terms of procedure. We're very different from Lalonde and more like the Crosstech case. And I'll go ahead and go through my list of why I believe that we're different. Here, the lawsuit that Mr. Gonzalez filed against Momentum Design was on file for less than half the amount of time that the Lalonde case was, and it was less than 2 years. In Lalonde, the motion to dismiss was not filed until 492 days after the first of the 2 mediations. Those 492 days are approximately the same amount of time that this entire litigation in this case was pending against Momentum Design. It was 523 days after Momentum Design filed its answer that it moved to dismiss. Unlike the Lalonde case, Momentum Design here did not participate in mediation, did not file motions for summary judgment. The discovery deadline had not passed. There were still 6 months. We were still 6 months away from that deadline when the motion to dismiss was filed. We did not designate experts, and we did not file the motion to dismiss on the eve of trial. There were still 7 months to the trial date when we filed the motion to dismiss. None of the scheduling order deadlines had passed as they had in the Lalonde case. We did file a motion to designate El Paso Electric as a responsible third party, but that was 2 days before the statute of limitations was going to run. That was early on in the case. I believe it was about a week after we had filed the answer. And just out of an abundance of precaution, that motion was filed. And the case law is clear that, when you're filing an answer and you're seeking to protect and acting out of caution and protecting your client's interests, that's not action that is indicative of waiver. So also in the Lalonde case, the court notes there was very little of the judicial process to invoke. Here, that doesn't hold true. There were no expert designations in this case. Mediations were still going to take place, presumably. Additional depots, supplemental discovery, exhibit list, trial prep. So I don't believe that this case falls along that spectrum that Lalonde does. 7 months time period before trial is the same time period the Crosstech approved, and that still is good law, Your Honor.
Ms. Lopez, just I think if you touched on it, but I guess what troubles me a bit about weighing these factors is when Momentum did draw El Paso Electric into the litigation to some extent, because obviously that's going to put some litigation burden upon El Paso Electric. and a number of deposition notices were sent to El Paso Electric employees. So I'm having trouble reconciling how that type of conduct, which is, it's not so defensive as much as it's being offensive against another party. How is that not being, how is that not inconsistent with a desire to preserve this dismissal right?
So by filing a motion to designate a responsible third party, that party is actually not brought into the litigation, and that party won't have any liability in the event it gets designated as a responsible third party. So I think, you know, that they're brought into the case is not true, Your Honor. Again, it'll let them be on the jury line to lessen, you know, the defendant's liabilities, but they're not actually brought into the case.
Well, but I mean, like, what are you, just what are you going to be gaining from, there were like 5 or 6 deposition notices to El Paso Electric employees. And what information would be gained by those depositions, which are going to be kind of disruptive to El Paso Electric?
Right.
So what do you gain that is helping to either preserve this right to dismiss the case versus litigating on its merits?
Your Honor, you're right. 6 notices of deposition were sent out, were filed. 3, if the record reflects that only 3 of those depositions actually took place. They were the project engineer from El Paso Electric, and then the inspector who was responsible for inspecting the final construction for CSA, I guess, completion of the substation. Because if we have to go back to the pleadings and see what plaintiffs' claims are. As the defendant, discovery is needed to determine how to best defend the lawsuit and find out what the real issues are. And discovery is the way defendants do that. If you look at the original first and second amended petitions that were filed by Mr. Gonzalez, they're identical copies. Nothing was changed. No new allegations were added. They're very general in just stating negligent, you know, installation, negligent construction, negligent design, failing to properly install. And those are, I guess, claims pled in the alternative. So in order to determine really what's at issue and determine, you know, let's explore the claims that are being asserted against my client and assure whether the claims actually arise out of the provision of professional services here. Let's depose the engineer, the plaintiff, and then the inspector. I would refer the court to the cases cited in my brief that show no waiver. For example, Ustanic, the court found that a period of 2 years and 5 months before seeking dismissal, participating in discovery and filing motions for summary judgment did not constitute waiver. In DLB Architects, the court did not find waiver where the delay of more than a year in participating in the litigation process. This is very different to the Lalonde case and the Murphy case, which was cited by appellants in their brief, where the court found waiver where there was more than a 3-year period that had passed before the defendant moved to dismiss. So again, why did we need to do discovery? It was to learn about the case and decide how to defend the suit. And if just as an overall, I guess, summary of the time that passed from the time that that Momentum Design entered the case in 2016, that paper discovery was done, particularly the notices of deposition, which is common practice in this common discovery. In 2017, those depots were taken. As indicated, the 3 depots that are indicated in the record. And then in 2018, other than doing limited discovery, designating that responsible, making that motion for designation of responsible third party, and then moving to dismiss, those are the only actions Momentum Design took in this case. Once it filed its motion to dismiss, other than that, there was no, substantial litigation of the merits in this matter.
Ms. Lopez, are you telling the court that the motion to dismiss based on the failure to file the merit certificate, that was intentional and strategic?
I'm sorry, Your Honor, I'm having trouble hearing you.
All right, hold on just a minute. Let me just. Can you hear me a little bit better now?
It seemed
Yes.
like,
Yeah. So the fact that Momentum waited some 17 months, conducted some discovery, answered, that was an intentional and strategic by Momentum to do that before they filed their motion to dismiss?
no, Your Honor, they were doing discovery to learn about the case and whether or not that's a defense that was available to them.
Whether there was a defense of the filing of the merit certificate. So you're saying that the discovery was needed in order to find out if they needed to file, whether they could file the motion to dismiss on the lack of the merit certificate?
No, Your Honor, it was so.
I'm completely missing it. So it was intentional and strategic for them to do that. They did that on purpose, right? To wait 17 months?
I don't think I don't think that the intention was to, like, from the outset, the intention was to let's wait 17 months before we dismiss. I think the purpose of the discovery was to learn about the case. And
well, I mean, I understand that. I mean, discovery is always to learn about the case, right?
And then once they,
that's a given. That's a given. But I guess it's unfathomable to me, so I'm assuming it was intentional and strategic on the part of Momentum to wait 17 months to file the motion to dismiss.
I don't know if I'm understanding what you're saying. Like, if it was intentional that we just waited, like we knew about it, but we just waited, I don't think that's in the record, and I don't think there's any evidence to that. I think, a good lawyer does due diligence in learning about the case, and then, figuring out what steps need to be taken. And here, that's what happened.
Well, and that's not. I mean, that's absolutely true. I'm not negating that. I just think a good lawyer also doesn't sit on their rights and put their client in jeopardy of potential waiver.
Well, here, I don't think there was ever an intent to waive. I mean, the statute is silent as to when the defendant is required to assert that, I guess, right. And so I believe, as a party in a case, you're entitled to do discovery.
Well, obviously you're entitled, but I mean, that's not the question, and that's not the issue. Really, I'm trying to understand why anybody would wait 17 months. That I don't understand that. So I'm assuming it was strategic, because I don't know what else to think.
Well, I think in the record, go ahead, Justice Palafox.
Well, I don't know, I have a follow-up question, or maybe it's complementary to Justice Rodriguez. Let me go about it this way. When Momentum did file the motion to dismiss, is there something in the motion itself or the attachments that was the fruit that was born of the discovery. So so it's an indication of showing why it is that Momentum had engaged in the discovery.
So attached to the motion to dismiss was some of the discovery that was, completed through that.
Right, but what specifically should we be looking at to see that that's why this discovery doesn't show an inconsistency with the desire to dismiss the case, as opposed to gaining a decision on the merits?
Well, I don't think just by exchanging and participating in discovery in this case, that shows an intent to waive. I'll point out that when Momentum Design was brought into the suit, Mr. Gonzalez served Momentum Design with its discovery requests. So, that is just part of the process, if that.
Yeah, so I think what we're both asking is maybe you chose to engage in the discovery and you have a right to learn about your case, and we don't dispute that, but I'm just trying to understand, did you gain anything from that discovery that was significant to the motion to dismiss?
Well, I think Momentum Design did attach Mr. Gonzalez's depo testimony, and then also the discovery that it obtained from CSA constructors that just confirmed that the issue was a negligent design. The issue that the issue at hand was going to be a negligent design action or claim, because if you do go back and look at the pleadings, it's not very clear at the outset. And again, there's no bright line requirement of when to file a motion to dismiss, and case law allows for discovery to be conducted. The Supreme Court has not held that nothing can be done other than filing a motion to dismiss. And so here, Momentum Design did what it was allowed to under the law, and made a determination of when it was appropriate for it to file its motion to dismiss.
Go ahead.
The statute, I know you're at the end of your time, Ms. Lopez, but the statute explicitly says that you didn't have to file an answer, but you voluntarily chose to file an answer regardless.
Correct, and there's case law, Your Honor, that doesn't prevent a defendant from filing an answer.
But it's certainly intentional conduct to file that answer.
I'm sorry?
It's certainly intentional conduct to file that answer.
It is intentional. I mean, you intend to file an answer once you file it. But again, the courts have said that acting out of caution and protecting interest by filing an answer is okay.
Even when you don't have to file an answer.
Correct.
Okay, there are no other questions. Hold on one second. Mr. Pownell.
Yes, Your Honor. Ready?
Yes.
Okay, thank you.
You're good to go.
Okay. Justice Palafox, you asked counsel a question that I think is very important. Did you gain anything from discovery significant to the motion to dismiss? And I cannot emphasize this point enough. The Momentum could not gain anything from discovery significant to the motion to dismiss as a matter of law, because discovery has nothing to do with a Chapter 150 motion to dismiss. The only thing that allows a defendant to file a Chapter 150 motion to dismiss is when you don't have an affidavit attached to your petition, or it's defective. Now, it's a little more complicated if it's defective, but we didn't attach anything. So the only piece of information throughout this entire litigation that Momentum needed to have in order to know that they could file a Chapter 150 motion to dismiss was whether there was a Chapter 150 affidavit or an affidavit required by Chapter 150 attached to the petition.
Well, don't you still have to kind of show counsel kind of the predicates that it's a case based on the design or defective design, I guess, from a registered professional engineer or architect, and that's kind of connected to whatever the injury is. I think that, yeah, they attached Mr. Gonzalez's testimony for that causation element, that he was claiming that the lack of the brace was why he injured himself.
Well, those have to be part of the affidavit. But if you don't have an affidavit at all, you don't have to know anything more than that. Well, I guess I think maybe I see what you're saying. You do have to examine the pleading. I mean, obviously, if you're Momentum Design and Construction Inc., you're probably going to have a pretty good idea that this claim is going to involve Chapter 150. But I guess if you're Momentum, you need to read the pleading and see what the pleading says, and then say to yourself, "Oh, this is a Chapter 150 case." So I'll grant you that, Your Honor. I mean, it's it's not just an affidavit all by itself, but as long as the pleading pleads a claim that's covered by 150, which is what Momentum's arguing, the only thing they have to know in order to know that they're entitled to bring a Chapter 150 motion to dismiss, the only thing they have to know is whether an affidavit's attached to the petition. Now, even aside from that, Your Honor, even if we give them the benefit of the doubt that the petition itself wasn't clear enough, we also know that 6 days after they answered, CSR filed their motion to designate responsible third party. And then in that motion, I think without any shadow of doubt, and I don't know how you can even argue with a straight face from the plaintiff's pleading, and maybe the better way to say it is Momentum has never made that argument. Momentum has never made the argument that we couldn't determine the Chapter 150 applied based on the plaintiff's pleading. In fact, second amended petition, if I'm not mistaken, was the same petition, was the live petition when they filed their motion to dismiss a year and a half later. So that really helps me. I can double check that, but I'm almost positive that the second amended petition that the plaintiff filed, that the plaintiff sued and served Momentum with, was the live pleading when they filed their motion to dismiss a year and a half later. So
can I ask you another question? And this one's a little off topic from where we were, but the position that was taken below by your client, as I understand it, was if there was going to be a dismissal for Momentum, that precluded the responsible third party claim by CSA, because it was, I guess, an adjudication, and CSA could no longer claim that Momentum was a responsible third party. But the position on appeal is that we should convert this into a dismissal without prejudice. And I was just trying to reconcile those two positions.
I don't remember the lower court decision, position, Your Honor. What I can tell you is that on appeal, we did argue, kind of as an alternative, argue that the trial court abused her discretion in granting it with prejudice as opposed to without prejudice. The reason I haven't focused on that is we're beyond limitations as a practical matter. That's not going to do us any good. But I went back and forth on whether they even put it in the brief, but it just bothered me that it was dismissed with prejudice, because I don't think that the even worst case scenario, these circumstances didn't justify a dismissal with prejudice. But be that as it may, that's it is in our brief, and that's something that the court can consider. But as a practical matter, it doesn't really help us. As for the lower court position, I'm not sure I followed you completely, Your Honor. We argued.
It was an alternative position that if the court was going to dismiss Momentum, that it also essentially needed to dismiss the responsible third party claim against Momentum, so that CSA couldn't apportion
Okay.
liability to Momentum.
Yeah, that is that's an argument that that probably is an argument we made. Whether that would apply, there is some case law that suggests when you get a ruling on the merits, like a summary judgment finding, then that's the law of the case, and that there's an issue preclusion issue. But I don't. The court never ruled on that. I don't believe the trial court didn't.
And then just remind me when there's this colloquy where the trial judge says, "I'm not going to rule on waiver," but then maybe a few minutes later said that she does. Is that as to the original motion, or is that as to the motion for new trial?
I thought she made it very clear in the original motion that she was not going to rule on waiver. It
Okay.
is more ambiguous in the.
Okay. So, and then in the motion for new trial, which you raise waiver, is there an order that just denies the motion for new trial?
That's my memory. All right.
Okay. And so why isn't that a ruling on the waiver issue then?
Because I don't think that's an issue that we had to raise in a motion for new trial in order to preserve on appeal. We just had to raise it in our motion. But be that as it may, I'm going to take my last few seconds to try to clear up this procedural issue on waiver, because I don't think that really matters anymore anyway. Unless, I think there's two paths here, Your Honor. If the court believes there are disputed facts, then it does matter, because then either the court didn't rule or she ruled. If she didn't rule, it needs to go back to her. If she did rule, though, then there's an implied finding, and all those disputed facts are resolved against us because she ruled in favor of Momentum. But all that just depends on whether there are disputed facts. If there are no disputed facts, then it's just a non-issue, because it's just a matter of law that this court decides under. That waiver is just a matter of law that this court decides under de novo review. So after I read the Lalonde decision, where the court emphasized that, and where the Supreme Court emphasized that in Lalonde, I went back and thought to myself, what facts do we have that are disputed with respect to the waiver issue? Excuse me, Your Honor. And I don't see any. I'm not aware of any. Nobody's disputed. These things all kind of happened they're all part of the record. No one's disputing, when the answer was filed, how long it took for Momentum to file the motion to dismiss. But I do believe that whether the trial court ruled on the waiver issue, it does matter if there are disputed facts. Because then if there's disputed facts, if she did not rule, then it needs to go back to her so that she rules. But if she did rule, whether, if the court believes, for example, if she ruled as part of the motion for new trial, and if the court believes that's sufficient, there's the rule on what's required to raise in a motion for new trial in order to present on appeal. And which I don't think that's something that we had to do. But if the court sees that otherwise, then the court doesn't need to send it back for her to decide. It's just an implied finding that any disputed fact would go against us. But to me, the larger issue is where are the disputed facts? I don't see any. And since there are no disputed facts, and Momentum has not pointed to any in its brief, in fact, made the argument, as I said at the very beginning, which maybe I got ahead of myself, but if you look on page 17 of Momentum's original brief, Appley's brief, they make it clear that they don't believe there's any disputed facts either. They said that, the court's finding was based on undisputed facts. So now we're just left with a matter of law decision. But what's really helped us is Lalonde. So let me end with, let me go back to what Justice Palafox, I think, was alluding to, which is the totality of the circumstances test. And I'm going to read from the Lalonde decision. Arbitration and forum selection cases involve rights that do not terminate the litigation. Rather, those rights at best change the arena of dispute, and in doing so may change the rules of engagement. Here, in comparison, the rights arising under Section 150.002 eliminate the obligation to litigate at all. Emphasis, italics are in the text of the opinion. the obligation to litigate at all based on the plaintiff's failure to raise a preliminary fact issue on the merit. The right to dismissal under 150 arises solely and exclusively from the requirements in sections 150.02a and b, that an engineer certify the merit of each theory of recovery. So go ahead, Your Honor.
Well, I was going to say, you may not be able to see it, but your time has expired. So if there are not any other questions, let me thank both counsel for excellent argument. This is a very interesting case, and we appreciate your good briefing and your professionalism. And you will hear from us.
Thank you.
So that
Thank
Thank you,
you.
Your Honor.
concludes the argument today.